Good afternoon, everyone, and welcome to the World Affairs Council Upstate, America and the World Flashpoint Lecture Series. I'm Tracy Freeze. I'm the Executive Director of Upstate International and the World Affairs Council Upstate. I want to welcome you today and thank you for taking your time to join us in listening to this subject, Checks and Balances, Presidential Powers in Times of Crisis. This subject is obviously very timely, and we hope that you will join us in the spirit that we bring these programs. We're a nonpartisan, non-political organization dedicated to foreign policy, global impact issues, and current global events. And our goal is to bring national and international experts on topics that impact us both here and abroad in a manner that is as academically based and as realistic with the facts we bring you. So we ask you, when you type in your questions today, which our moderator will deliver to our speaker, please keep it in that spirit and bring forth your questions. Right now, what we all need is education and compassion and time with each other in our community and as our nation to all heal and do better. We do hope that everyone understands for the World Affairs Council, Upstate and Upstate International, we truly believe that we cannot fully embrace and appreciate global diversity until we help solve our own racial inequities here at home. We hope you'll join us in learning more about our government, about the balances built into our system, and what we can do with that information and knowledge. Today, I'm very grateful to have, as our introductions are made, our own World Affairs Council Upstate Steering Board Chair, Rob Rowan, who will introduce our speakers. So I'm going to turn it over to Rob.
Hello, everybody. This is a very timely one, and I want to thank Tracy, our Executive Director, and Kim Fowler, who have worked tirelessly to help put together this whole group of Zoom agenda meetings we've been doing. I will again ask if anybody is touched by what we do and says, I want to support that, we can always use your support to be a sponsor. It's not a lot of money, but it certainly will help us in furthering the work we do of educating. I get the great opportunity to introduce these two great speakers. Our main speaker, Steve Buckingham, which he is a lawyer, mediator in Greenville, whose practice is on business disputes. He is not a native South Carolinian and born in East Tennessee, so he's a volunteer fan, as you would well imagine. He did graduate from Furman in 2003, magna cum laude, and Phi Beta Kappa with a BA in political science. In 2006, he graduated University of Richmond, go Spiders, School of Law, magna cum laude, and he served as the editor-in-chief of the Richmond Law Review. Why he is here today is this is some of the things that he has been dealing with in constitutional law. He has expertise in state and federal jurisdiction, federal contracts clause, First Amendment freedom of speech and defamation, First Amendment freedom of religion, Sixth Amendment right to confront accusers, the Sixth Amendment right to adequate legal representation, the Eighth Amendment right to be free from cruel and unusual punishment, equal protection under the state and federal constitutions, due process under the state and federal constitutions, and voting rights under the state and federal constitutions. So I think he has a little bit of background with the Constitution for some of us who think, okay, there's only really 3 or 4 amendments to deal with, but this is something. Just to give you a little bit other background to tell you who he is, he has been, his top 4 pursuits are the evolution of the rule of law and how legal procedure was applied or abused as singular moments to shape the course of history, which is where we're at right now. Battlefield strategy and tactics, another good one. Stoic philosophy, and the work of credible futurist philosophers. So, Steve, that is fantastic. And with him, our moderator is William Lasser. And William is the alumni distinguished professor of political science at Clemson University and the director of Clemson Calhoun Honors College. He has his PhD in political science from Harvard, a small school somewhere up in the Northeast, and the author of numerous books and articles on law and American politics, including The Limits of Judicial Power, the Supreme Court in American Politics, Benjamin versus Cohen, Architect of the New Deal, and he also taught constitutional law, American government, and political theory at Clemson. He's also a member of the World Affairs Council Upstate Board, representing Clemson, and he's also a good friend of mine, and I think you will find him to be fascinating. So at this point, thank you for coming. Enjoy your lunch. Enjoy this great talk. See you again, and now let's have it handed over to William Lasser.
Thank you, Rob, and good afternoon, and welcome everyone. I'm delighted that all of you have joined us for this conversation on the contours of presidential power. The contours of presidential power may be the defining issue of our time, and I think that's true whether you define our time as, I don't know, since 1776, or since 1787, or since the New Deal, or perhaps since 9/11, or perhaps since the beginning of the Trump administration, or perhaps since the beginning of the week, or even the weeks and months and years to come. And I'm delighted that my colleague, Steve Buckingham, is here to lead off our conversation with some remarks on this topic. When Steve finishes, he and I may have a little bit of conversation back and forth, but we welcome your questions at that point and at any time afterward. Ideally, we'll spend most of the time after Steve's remarks answering your questions and talking about the issues that matter to you. So with that, I'd like to turn it over to Steve, and we're very much looking forward to his remarks. Steve?
Well, thank you very much, Bill, and thank you to the World Affairs Council for hosting this, and thank you to all of you who are out there listening in Radio Land. I am pleased that so many folks tuned in and seeing some of the names on the screen. It looks like I've got some friends out there. So first of all, let me begin with an overview of what I would like to accomplish during this time that I'll be speaking. First of all, I think it would be remiss if I didn't acknowledge the complications with preparing this discussion. The contours of presidential power is a very broad topic. And so trying to fit that into the time that we have allotted together is, frankly, damn near impossible. So we are only hitting the mountaintops, really, of the challenges and all the issues that are to explore in that context. Now, I think it's also important to recognize that current events have made preparing for this discussion a little bit more challenging. I was sharing with Bill and some of the other folks from the World Affairs Council here recently that I've had to revise my outline several times over the past few weeks, including last night. So I'm now on my 4th revision, and it is as late breaking as it can get. Although I did limit myself to not look at the news this morning, so maybe something else has happened that I should have put in my outline, but I had to draw the line somewhere. So here's what I want to accomplish in terms of my objectives for this. First of all, I want to spend some time covering the historical origins of the Constitution and the authority of the presidency. What were the concerns that our founders were trying to address, and then how did they try to address that? Second, and this will be really the meat of the discussion, I believe, it will be the evolution of presidential power. And that's mainly just going to be looking at the topics, the flashpoints really that have occurred throughout the past 240 years of American history, where the president has assumed more power than maybe the Constitution allows, than maybe the founders perceived, or maybe that was appropriate to the circumstances. The third topic we'll be looking at today. Where are we today, and what are some of the modern flashpoints that we're encountering? And I imagine that when we get to the question portion of this, I'm hopeful that a lot of you will have questions about that to dig in on what is on your mind. And then the fourth thing is my humble attempt at prognostication. Looking into the future, what are the battlegrounds going to be in terms of presidential authority under the Constitution, maybe next year, maybe in the next generation. But also as part of that looking forward, we'll be looking past, looking to the past. A lot of our modern challenges we find echoing in the past. And so you always hear the phrase, the past is merely prologue. And I think that's very true about this very issue, and what authority we are comfortable having the chief executive of the United States possess and wield. So, first topic, historical origins of the Constitution. To kind of reiterate what Bill was saying a moment ago in his introduction, where do you start with this? It would be easy to start with 1787, of course, with the Constitutional Convention. We could go back to 1776 with the Declaration. I would encourage us, and I'm going to start just a little bit earlier than that. I'm actually going to start in 1763. And the reason why I've picked that date, it's not arbitrary. That is the year that the French and Indian War came to a conclusion. As you all might know and appreciate, through a great deal of the 1600s and the 1700s, England and France loved to be at war with each other. And so from 1754 to 1763, they were fighting their colonial war in the United States, in the colonies at that time. And of course, the French had allied with Native Americans against the British and the colonists. At the end of the French and Indian War, a peace treaty was achieved by which the French were largely expelled from the colonies, and there would be no more French incursions, threats to the colonies. And I'm going to use this in a loose sense, peace had been achieved with Native Americans, in the sense that Native Americans were not allied fighting against the colonists. Of course, there still were incursions all along what at that point was the western border of the colonies. But there wasn't a sustained conflict going on. So, 1763, we're at peace. All is great in the British Empire. But not too long thereafter, challenges started to be presented from the colonists themselves. As part of the 1763 peace treaty, Britain had agreed that its colonists would not go west of certain boundary lines of the colonies that existed at that time to preserve French claims to the New World and also to Native American claims. A lot of colonists disregarded that, and frankly, probably some of my ancestors. They picked up and went west and encroached onto what at that time were still Native American grounds. Now, this became a challenge for the British because, first of all, they had committed to a treaty that they would not allow these incursions. And second, it was threatening to destabilize the peace that had just been achieved. Now, the law that Parliament passed that prohibited westward expansion and frankly required pioneers to move back east, but that was disregarded. That was an unpopular move generally in the colonies, but it wasn't so unpopular that people cared that much. There were other issues in addition to that started to give the foundation for colonial frustration with Parliament. So in addition to the prohibition on westward expansion, Parliament, being very well aware of their financial circumstances, decided that the war that they had just got done winning in the colonies was very expensive and they needed to finance it somehow. And it made sense to them that since the colonials were the beneficiaries of the conflict that Britain had prevailed in, that they should bear the brunt of that expense. And so a number of taxes were passed on the colonials in order for Britain to recoup a significant amount of the war debt that it incurred prosecuting the war on behalf of the colonists. So we know some of those taxes. We have the stamp tax, we have a tea tax, we have various forms of wealth taxes. In fact, if you've ever been to President Washington's estate in Virginia, you know that there are not many doors there because there were door taxes. That was just another form of a wealth tax that was imposed. And so you have the merchant and wealthy class of the colonies that are being disproportionately affected by these taxes. Now, in fairness to the British, and somewhat in fairness to King George, it wasn't King George that was declaring that these taxes be imposed. This was the British Parliament that said that taxes should be imposed. This was the representative government of the British Empire saying, we need to recoup this war debt, and we're going to impose this on the colonists. And of course, the king went along with it. But see, that's where we get this idea of no taxation without representation. The colonists said we don't have representation in Parliament, so why should we be taxed disproportionately? The truth is, the colonists did have representation, just non-voting members, much the same way that we allow folks from Puerto Rico and Guam and other U.S. protectorates to send delegations to Congress. They're there to advise, they just don't vote. In any event, from 1765 to 1770, there's this growing frustration within the colonies that is largely economic and directed towards Britain. But in 1770, really beginning in 1770, we see the transition of that frustration go from economic to political. And really the singular event that caused that transition was the Boston Massacre. As a consequence of the Boston Massacre, colonists began to perceive themselves popularly, widely, they began to perceive themselves as being regarded by Britain as something less than equals, that they were subjects of the British Empire, secondary to citizens of Britain, and not equals, not equal British citizens. And as you can appreciate, that was a source of significant frustration for the colonists. They very much wanted to be equals with regular British citizens. So this popular sentiment starts growing about how the colonists are something less than equals with their British counterparts. And then the Boston Tea Party happens, 1773, December of 1773. That was in direct response to favorable tax treatment that Britain had given to British tea importers to the exclusion of merchants in the colonies. So a group of about 60 Sons of Liberty, who were also the merchant class of Boston, stormed 3 ships in Boston Harbor, threw tea overboard, and thought, well, we really should show the British. Well, this is a great example of how not to over-respond to a crisis, because everything that comes out of the Boston Tea Party not only foments the American Revolution, but also the structure of the Constitution that followed. The first thing that happened in the first few months after the Boston Tea Party is King George perceived that that there was a very serious insurrection going on in the colonies, and that Massachusetts in particular was in a state of insurrection. So he deployed a significant number of British soldiers to Massachusetts who would be stationed there. They would be garrisoned there. But it wasn't just King George's response, it was also Parliament. Parliament responded to the Tea Party with some pretty onerous, but frankly probably not unreasonable, laws targeted at the colonies. First of all, to the extent that British soldiers were garrisoned in the colonies, they would be required to be housed with colonial families. And so it's not just British soldiers who are in the colonies. A lot of times it's also the families of the British soldiers who are now living with colonial families. And there was a dual purpose to this. First of all, obviously suppression, right? But second, it was again, a cost savings type of measure because Britain was so indebted from the French and Indian War. So that was the first thing, quartering of soldiers. Second, Parliament closed Boston Harbor until Boston made restitution for the cost incurred by the Tea Party, which, as I understand it, was about $18,000 in money at that time, which today, I mean, that would be a significant amount of money. So they ordered restitution. Third, they put Massachusetts under military jurisdiction, meaning military governors and military tribunals instead of civilian courts. And fourth, as a direct response to the Boston Massacre, they made British officials immune from prosecution. Well, this kind of threw fuel on the fire of the colonial sentiment of being second-class citizens, and this resulted in the First Continental Congress. And at this time, the congressional delegations from pretty much all the colonies except Georgia, they convened and they decided that they should make some sort of appeal to common sense to Britain. But certainly at this time, there was no discussion and certainly no popular support of independence from Britain. Instead, they just wanted to get back on a right relationship. So they put together a petition to King George for a redress of their grievances, and that was soundly rejected. Moving into 1775, as popular sentiment continues to bubble just underneath the surface of frustration with Britain, you had a detachment of soldiers from Boston that were sent to Lexington and Concord to confiscate the arms caches of militia. And of course, that resulted in the shot heard around the world, the first shots of the American Revolution, the birth of the American Army, the Minutemen, all that stuff. That was Lexington and Concord in April in 1775, and that was a direct consequence of Britain trying to confiscate the arms of colonial militias. That led to the Second Continental Congress, which met in 1775, and of course in 1776 produced the Declaration of Independence, formally declaring independence and frankly war on Britain. So the Second Continental Congress continues until 1781 as the de facto government of the United States. It's a wartime government, but as soon as they declare independence, they're also looking around at each other thinking, well, gosh, what do we do now? Now that we're an independent government, I guess we've got to form a government. So as the War of American Independence is raging over the next 5 years, the Continental Congress is also busy about drafting a national government structure. What they produce is the Articles of Confederation. That's ratified in 1781. Now, this is really the first time that the term United States of America is formally used. And the founders, and I think this is a very important point, the founders were very deliberate in choosing that word state when they describe the union of colonies. In their mind, a state was the highest political organizational structure that existed. It was the sovereign. There was nothing above it. And so this idea of a United States, it was 13 independent states in the same way that Britain was a state, in the same way that any other country of the world at that time was a state. You had 13 states who had formerly been colonies that were now their own political sovereigns who had come together in a union. Under the Articles of Confederation, the only governing body was Congress. States could send delegations, and there was one state and one vote, but there was no executive and there was no judiciary. It was apparent from the beginning that this was not necessarily an efficient type of government, certainly not to run a war, and then after the war concluded in 1783, to begin to finance the significant war debt that the United States had incurred. The best way to imagine this union of states under the Articles of Confederation is that it was just a contract among the states to set a united foreign policy, and not much more. So, for example, there was no taxing authority given to the national government. There was no one to enforce the laws of the national government. There was no one to settle disputes between the states at the national government level. This became a particular problem after the American Revolution, as each state was trying to finance its own debt load from the war, and they were trying to make up the revenue to service that debt by taxing imports from other of the colonial states. This was leading to a significant amount of friction and certainly plenty of discussion about how maybe this idea of a union was not such a good thing after all. So 1787 rolls around, and the states convene again with the initial purpose of trying to fix the Articles of Confederation. It was quickly decided that couldn't be done. There was no way to amend it that did not would not result in the creation of a new governance structure. So the framers of the Constitution set about to develop a new document, a new governing structure. They were trying to operate within a couple of parameters: lessons learned from their time as colonies under Britain, but also lessons learned under the Articles of Confederation. One of those parameters they were operating in is they had to conceive a form of government that would preserve the individual sovereignty of states, while ceding an amount of authority that was sufficient, but not greater than necessary, to enable the national government to participate in the community of nations, but in a way that was faithful to the vision of what the framers were trying to achieve. And we know what the framers were trying to achieve because they set out that vision statement in the preamble to what became the Constitution. We see 6 things that the national government has primary responsibility for trying to accomplish. And that is, 1, to form a more perfect union; 2, to establish justice; 3, to ensure domestic tranquility; 4, to provide for the common defense; 5, to promote the general welfare; and 6, to secure the blessings of liberty for that generation and for generations to follow. So that was the primary goal. How do we form a national government and preserve the sovereignty of states? Within the idea of a national government, they knew that they were going to have to create a government that could not only make laws, but also enforce and interpret the laws. But they were concerned, because of their time as colonials, that if you vest too much power in the national government, certainly in the executive, that you run a substantial risk of falling back into a tyranny, what they just escaped from. They wanted to preserve this idea of states being able to commune together in a national legislature and delegate authority to the president in order to execute the laws that were necessary to preserve the Union. So in that connection, they developed what we now know as our 3 branches of government: the executive, the legislative, and the judicial. These are allegedly co-equal branches. And I use the word allegedly because I don't think anyone has ever thought that that is the case. And certainly not the founders. In fact, I think we need only look at the text of the Constitution to see which branch they thought was the first among equals, and that is, without a doubt, Congress. It is Article 1 of the Constitution. It is vested with many enumerated powers, and it is vested with many unenumerated powers. We know those unenumerated powers more colloquially as the necessary and proper clause, that Congress is authorized to make any laws that are necessary and proper to carry out any other laws that are, or any other powers that are delegated to them under the Constitution. A lot of flexibility there. Then we get to Article 2, which is about the executive. Compared to Article 1, there are very few powers that are enumerated, and they're very specific. Many of those powers that are granted to the executive require congressional approval before they can be exercised. And perhaps most importantly, towards the bottom of the text of Article 2, one of the very discrete things, one of the very discrete responsibilities of the executive is to take care that the laws of the United States be faithfully executed. Then we get to Article 3. Article 3 is the judiciary. We'll talk more about that in a moment. When we look at, compare Article 1 and Article 2, we see very clearly that when it comes to domestic matters, the framers of the Constitution intended Congress to be in control. When it comes to general foreign matters, we see an intent for there to be a sharing of power between Congress and the presidency. Certainly, the president is the point person for the United States to participate in the community of nations around the world. But when it comes to entering into relationships, treaties with those other countries, or designating ambassadors on behalf of the United States to those places, certainly the president can nominate individuals, but it's Congress that has to approve who those individuals will be. So there's shared control when it comes to foreign affairs. And particularly when we get to the power of war, the framers were very concerned about the ability of the president or any executive to use this at his unfettered discretion. So we see kind of like a phased type of control structure here. When it comes to standing armies, the framers didn't like this, didn't like the idea of standing armies. They were disfavored. And so that's why we see appropriations for military limited explicitly in Article 1 to no more than 2 years. When it comes to domestic deployment, we see, again, in Article 1, that in the event of insurrection or invasion, Congress can authorize the president to deploy military forces domestically. And then third, when it comes to foreign deployments, we see that it requires the Constitution requires a declaration of war before the American military is committed to hostilities. Now, a point on war. In the late 1700s, the world was in a very binary place as far as what the state of nature was among the community of global citizens, the nation states of the world. You were either at peace or you were at war. There was not much opportunity for a shade of gray between there. And war was very simply understood as any act that was in derogation of another country's sovereignty. So, like I said, very binary world. You're either at war or you're at peace with another sovereign entity. And to drive the point home, before the President of the United States could commit forces to war, Congress had to declare that a state of war existed. Now, before I move on, I want to just raise a quick point here about what a purpose of the Constitution was not. And it was not to define in any way, shape, or form the scope of the relationship between an individual citizen and the national government. That was irrelevant to the framers. Individual citizens had rights in relation to the states in which they lived. And states had rights, some of which were ceded in the form of power to the national government. But there was no real direct relationship between the national government and the state, or the citizens of states. And even though the Constitution says things like "we the people," well, that's a euphemism. The people referred to the union of states, states coming together. And that is the people. And that's reflected not just in the text of the Constitution, but also in the Bill of Rights that came 6 years later. Every time in the Bill of Rights that it's talking about the people, that was very well understood at that time to mean restrictions that were imposed on states by the national government and not limitations on the power of the national government on citizens, because that simply would not have happened. States would have had the discretion to regulate their citizens. The national government would not have. That would have been seen as a severe overstepping of the authority granted to the national government. One other point, just to make real quickly, the Bill of Rights. If you go back and look at those first 10, those were in direct response to everything that came from the Boston Tea Party. The rights of freedom of assembly, freedom of speech, freedom to be free from quartering soldiers, freedom to possess firearms, all of the Bill of Rights, all that was a direct response to the oppression that the colonists perceived coming directly out of the Boston Tea Party. So that's what was on the founders' minds when they framed the Constitution. Now we transition into the evolution of the Constitution itself. The framers thought they had solved this problem of power being concentrated in the hands of the executive by instituting checks and balances. And of course, we hold up checks and balances as one of the greatest inventions in a constitutional document that's ever been conceived. And they are very important. And we're going to go through and look at some ways that those have been limited, if not, in fact, eroded over time. But in terms of how the checks and balances were conceived, it was the natural presumption to the founders that the competing ambitions between those that were members of Congress and whoever occupied the presidency would naturally hold those two branches in check against each other. Furthermore, since Congress was given the power of making expenditures, the thought was if the president does something that Congress doesn't like, Congress can defund the president. We've seen in the Constitution that Congress can override the power of veto that the president is given. And the ultimate check that Congress has is impeachment and removal of the president. From the beginning, almost right out of the gate, there were challenges in what the scope of those powers given to the branches of the national government were. There were challenges internal to the branches, and there were challenges among the branches. And I want to be fairly critical of every president. Every president has exceeded their lawful authority, some more intentionally and deliberately than others, but they've all done it. And the fact of the matter is that was anticipated by the founders, and it was further anticipated that Congress would do something about it. Now, we've spent a lot of time talking about the legislative and executive branches. Where does the judiciary fit in? That was a question for the judiciary from the beginning. The judiciary was created in order to interpret the laws of the United States. But we see very early on in the life of the Republic a significant power grab that was made by the judiciary, and something that's become a bulwark of how we understand the judicial function in the United States now. And that is the power of judicial review, the power to review the laws of the government of the United States and to determine if they are constitutional or unconstitutional. If you look at Article 3, that's not a power that's explicitly given to the judicial branch. And it wasn't until the case of Marbury versus Madison in 1803 that this idea of judicial review was acknowledged. It was acknowledged by the Supreme Court itself, and it was a power that was seized for the judiciary by itself, and then everyone just kind of respected it and went along with it. It kind of made sense. Marbury is also an important case because it is the first time that this idea of a quote-unquote political question has arisen in the United States jurisprudence. And this idea of what a political question is, it means when there is a controversy that presents an issue within a branch of the national government or between branches of the national government, if the court feels like it can't make a decision that will necessarily be respected by those branches, it can bow out and refuse to take jurisdiction and say that this is a political question that should be resolved by the political branches through the operation of politics and not the law. It's kind of like an escape valve for the judiciary to say, we don't want to get involved. And we'll see why that is in just a few moments as we talk about the weakness of the judicial branch. So transitioning into that, what happens, and there have been plenty of examples of this over the course of American history, what happens when the president disregards Congress? We have, since you all know that I'm a natural-born Tennessean now, we have our first Tennessean president to thank for that, Andrew Jackson. During his presidency, he vetoed a law that Congress had passed regarding the banking system of the United States. When the veto went back to Congress, Congress overrode the veto and sent the bill back to Jackson, and then he disregarded that. It was a formal law of the United States that he had no discretion whether to enforce or not enforce, and to use the language of Article 2, that he, in fact, had a duty to take care that he faithfully execute, and he just decided, I'm not going to do it. It's a backdoor veto, right? The answer to that is when Congress disregards the president, we can go through the checks and balances that we discussed previously, and that's what Congress is supposed to do. They can defund the president and make his pocketbook hurt. They can, well, they did override the veto, but then it was disregarded, or they could impeach and remove a president, and that didn't happen with Jackson. We can also thank Jackson for answering the question of what happens when a president disregards the Supreme Court. The case in which this occurred, it was a decision regarding Indian relations with the United States, and the Supreme Court had made a decision saying that a certain law that Jackson favored because it was adverse to Native Americans was unconstitutional. And the apocryphal response by President Jackson was, the Chief Justice has made his decision, now let him enforce it. And that's not a hollow threat. If we look at Article 3 of the Constitution, there is nothing that requires or enables the judiciary to enforce its own decisions. It takes the president or the Congress to do something to enforce the decisions of the Supreme Court. Otherwise, the Supreme Court can make whatever decisions it wants to, and if no one will protect the integrity of that institution, the only authority it has is moral authority. There's nothing to compel the other sister branches of government to respect the decisions of the Supreme Court. You could also do what FDR did and decide, well, if I don't like the way that the court is ruling with me, then I'll just change the composition of the court. Again, if you look at Article 3, all that it says is that the United States must have a Supreme Court. It says nothing about how many justices must serve on it or who the justices may be. All that is set by Congress. Congress has set the number at 9, and Congress can change it, they can increase it, they can decrease it. Presumably they can't decrease it below 1 person, but then again, it's never been tried. And even if it were tried, it's hard to say who would hold Congress accountable for that. In any event, and pressing forward, what happens when a president just assumes power that maybe he doesn't have? And this may be an unpopular opinion here, but this is worth discussing. We can look to Lincoln for a lot of examples of this. Article 2 doesn't expressly authorize the president to call forth the militia on his own. He can do it after he has been authorized by Congress to do that. But we have plenty of examples in the Civil War of Lincoln calling forth the militia on his own without congressional approval. We have other examples from the Civil War of Lincoln spending money that was unappropriated in order to prosecute the Civil War. We have Lincoln suspending unilaterally the writ of habeas corpus during the Civil War, even though that is a power reserved to Congress. And frankly, the big question about the Civil War is whether or not states have a power, have an inherent right to withdraw from the Union. Lincoln answered that question for the states, but it's not a power that is given to the president necessarily to do that. Certainly, Lincoln is not the only person that has assumed power that is not necessarily his. We've got examples with Korea and Vietnam of presidents committing American forces to hostilities without congressional approval. That continues on to today with conflicts that are both known to the public and unknown to the public. We've got examples of questions about what happens when Congress just gives its power away to the president, particularly the power to legislate. Since FDR and the rise of the administrative state, we not only have the Constitution and the United States Code that provides our body of law, but also the Code of Federal Regulations, which deals entirely with the laws by which the executive branch conducts its agency functions. Those are entirely legislative matters that have been entirely, for the most part, delegated to the executive. And that's something that's not contemplated by the Constitution. Well, certainly we've got plenty of examples of executive orders that are used to legislate. And if the legislation is done within the scope of the executive branch only, there's probably not a problem. But what happens when the president starts issuing executive orders that affect money that Congress has already appropriated, or even create law where none has existed? That is very shaky constitutional ground. But every president, certainly the modern presidents, have done it. Another great example of Congress giving its power away is the War Powers Act. In an effort to resolve this tension between Congress and the presidency about who can commit forces when, and do you have to have congressional approval? Congress passed the War Powers Act in order to say, hey, look, all right, President, all right, you can commit forces for 60 days, but then beyond that, you've got to come back to Congress for approval. Every president has disregarded the War Powers Act. Congress likes to mention the War Powers Act, but no one really believes that it would be held enforceable. It's probably just a nicety that exists, but it represents a substantial delegation of the war-making power to the president. And maybe the ultimate question through all these examples of evolutionary increases in the scope of presidential power is, what happens when Congress doesn't seem to care about presidential excess? If Congress doesn't seem to care, then really there is no recourse to presidential excess other than an election. That's it. So where are we today? It's not clear that states have retained much semblance of sovereignty. I'm not going to say it's been abolished. It still does exist, but it is a shell of what the framers intended state sovereignty to look like. Even though we are, and certainly we do, even though this is a federalized structure, it is not so much fair to say anymore that the states and the national government are coextensive governing entities, equals. There's not much evidence, certainly law, that is the case anymore. To some extent, states do retain sovereignty, but that erodes year after year. It's not clear that Congress takes its role as a co-equal branch, and certainly as the first among equals, very seriously. Congress has ceded, either explicitly or by abdication, a great amount of authority to the president. As a consequence, powers become a lot more centralized in the hands of the president than the framers intended or would have preferred. So consequently, when we talk about the scope of the power of the national government, to a large extent, we are talking about the scope of the power of the president. And what does that mean for individuals, common folks like you and me? Well, the scope of national power is expansive. When it comes to our property, certainly the government can take property by condemnation, eminent domain. And a quick note about that, you always think about condemning property to mean real property. There's no limit in the law that would suggest that condemnation is restricted to real property. There is no reason why the government can't condemn intellectual property, take intellectual property for its own good. Now, it's got to pay just compensation for that, but there's no reason why it can't do that. We also have examples of like the Defense Production Act, where Congress has said, yeah, President, in your discretion, you can decide to take over the manufacturing aspects of the United States in order to protect national security or defense. And that is, that's a broad power that is questionable even for Congress to exercise, and dangerous to give to the discretion of a person to wield. Certainly, there are examples throughout history of the president taking individual liberty. The best example of that is the German and Japanese internment of American citizens in World War II. Now, that has since been held to be an unconstitutional act, but for a long time, that was a very constitutional act. It was explicitly approved by the Supreme Court. We see echoes of that today with the border detentions going on along the southern border of the United States. And I think there's great arguments about how, as unpleasant as this is to say, that the scope of the national power and maybe the power of the president includes taking life, or at least risk of taking life. And a great example of that is through military conscription, the draft. The lesson of these past few hundred years, and certainly the past few years, has been that so much of the integrity of the republic hangs on good faith. It hangs on those who are elected to trust that they are acting in concert, though not necessarily in unison, to promote a shared vision of the republic embraced by the Constitution. There's so many what ifs, so many hypotheticals, so many crises that erupt year over year that we have to face as a country, and there's no way around that. They're unavoidable. But I think the best that we can hope for is that our elected officials have good judgment and are guided by fidelity to what this experiment was to be all about. Looking ahead, I think there are a couple of significant battlegrounds in terms of presidential power and the Constitution ahead of us. I think the integrity of elections is a tremendous one that is facing us right now and will continue to face us for quite some time. Privacy, particularly when it comes to data privacy and the compromises made of data privacy for national security interests, I think that's going to be a huge battleground. Preservation of the freedoms of speech and assembly. You know, when I talk about revising my outline, that's why. You know, just candidly, I was horrified to see what had happened in Washington 2 nights ago with the clearing of Lafayette Square. An ongoing crisis is judicial independence and integrity. I sense an unwillingness to defend the Supreme Court and the integrity of its decisions, and ultimately that impairs not just the rule of law, but the confidence that we have in the rule of law as citizens of the United States. It takes away from the predictability of the system. It takes away from believing that there is equal justice under law. I think that is a weakness that is built into the system, but is increasingly becoming a material concern. And finally, I look at taxation as a significant issue. Taxation and the weight of debt. We see from how America was born that it was grown out of this economic frustration. And the economic frustration was caused by servicing war debt. And we can look to examples throughout history of governments that have undergone cataclysmic revolutions because, if not in part, then in the whole, because of debt incurred through war. And it concerns me that the United States seems to be perpetually engaged in warfare that we are always paying for without a plan for how we're going to pay for it. And that concerns me about stability. So I hate to be such a downer. I do have many concerns about the constitutional structure, but I welcome your questions and I thank you for hanging with me.
Well, thank you, Buck. And we definitely welcome your questions, and I'll be monitoring them and trying to relay them to our speaker. While you're contemplating that and getting your questions in order, Buck, I'd like to come back to this question of good faith that I think is really at the center of your argument. It seems to me the pattern that we've sort of fallen into is that the president makes some sort of claim. It might be well-grounded, it might be outrageous. Then Congress seems to lack, at least at the moment, the ability to enforce that claim by itself. I'm thinking, for example, of subpoenas to executive officials. So they go to the Supreme Court, or go to the courts, and that wends its way through a process which takes a very, very long time, and certainly does not get resolved in a timely fashion. And I'm wondering, as a lawyer particularly, if you think the law has any remedy, even if the Supreme Court is willing to make those decisions, given the sort of difficulty of timing and given the president's sort of, any president's, but particularly the current president's pattern of sort of trying to run out the clock on these kinds of issues.
Yeah, so I think it is a waste of time for Congress to go to the courts to try to enforce any subpoenas against the executive. I think I think what we are likely to see from the courts in resolving that issue is this invocation of the political question doctrine that I was talking about before. And I think there could be two reasons for that. One of them is a cynical reason, which may or may not be the case, but the other one is just kind of a structural reason. The cynical reason is I don't know that the court is interested in issuing a decision that they know the president is going to disregard. And I think that they are concerned about how that would impair the rule of law if a president flagrantly disregards their determinations. I think structurally, I think there's a good structural argument there of it's not really the judiciary's place to call balls and strikes between Congress and the executive about what is a proper invocation of executive privilege and what is not. I think what the court is likely to do is to say, listen, the Constitution clearly identifies its remedies, the remedies available to Congress for a president who will not oblige congressional investigations. And that remedy is, impeachment and removal, ultimately. And whether or not Congress has the stomach to do that, that's not our call. So I think that I think if we're looking to the court for a remedy, I think we'll be staring into an abyss. I just don't think it's forthcoming.
Historically, sometimes the court, when it seemed to act at its most courageous, it's sort of after the fighting has stopped. I'm thinking of Party Milligan. Now, the war is over, and now the court comes up with this really wonderful rhetoric about how important it is to limit presidential power and at least wartime on our own soil.
Yeah,
and
sure.
Leading that pattern repeated.
Yeah, leading from behind. Sure, absolutely.
Yeah. We've got lots of questions already coming in, and so I apologize if we don't get to all of them. I'm going to try to sort of filter them over to Buck. But a lot of them concern, as you might imagine, many of the current issues. So maybe we can sort of run through some of these. One, which of course is from this week, is the issue of employing the military in states. The questioner asked without their consent. I might also add even with their consent. Could you kind of run through the law of deploying American military forces, National Guard, et cetera, in these kinds of circumstances?
Yeah, sure. So as I mentioned in my main discussion, the Congress is authorized to commit, to allow for the commission of United States military forces within the United States in the event of insurrection or invasion. Whether or not current events rise to insurrection or well, certainly not invasion, but insurrection, I mean, that, so with that backdrop, there are something like, it's more than a dozen. I want to say it's like 15 or 16 federal laws that authorize military force already on the books, going back to as early as 1807, that authorize the commission of United States forces domestically. And a lot of those give the president the discretion to decide if it is appropriate under the circumstances to commit those forces without a whole lot of parameters. It's just kind of like, President, if you think this merits it, you can go do it. So when it comes to a state that has consented to the deployment of military forces, I don't think that you have much of a constitutional problem with that. Politically, I think it's an awful thing, but constitutionally, I don't think that is offensive to the Constitution. It is a much tougher question when a state does not consent. And frankly, we can look back in examples where a president has deployed active military forces in a state against the state's consent, and it's a good thing, right? So great examples of that are desegregation in Mississippi and Alabama in the 50s and 60s. Thank God that the 101st Airborne was sent in to allow people of color to go to school. But of course, that was done over the state's objections. Now, of course, that's being used as precedent for trying to suppress the protests that are going on around the country, which is, in almost every case, a really awful, awful plan. The problem with that is going to be, well, it's twofold. It's not unclear constitutionally whether or not that's a problem, because a lot of these enabling laws that would allow active military forces to be deployed domestically, because they give the president so much discretion, that the president gets to decide the circumstances that merit it, and that is an example of where the court is not going to step in. To the extent that someone wanted to attack the constitutionality of a domestic deployment, I think that the best avenue of attack is probably on the amount of discretion that has been transferred over to the president, to say that transfer of authority from Congress to the president was unconstitutional because it is so vague. There's so few parameters about how to do it that it should be deemed unconstitutional. But if you lose that fight, then I think you lose every fight after that. I think you lose the fight about whether or not the deployment was constitutional, even over a state's objections. So I am skeptical that the courts would again provide any relief on that front.
It's ironic that the late Justice Scalia, even before he was on the court, was a great fan of what's called the Delegation Doctrine, which is the idea that the court should limit these delegations of power from Congress to the executive branch and to narrow them, at least to make sure the president doesn't have unlimited discretion. And now, of course, it's Republican president who's stretching the boundaries of that power, as you say, as every president has done pretty much from both parties. Let's go to a question about, there's a question about the executive order regarding social media companies, and maybe talk a little bit more about, please, executive orders in general, and how much power, for example, here, does the president have in his current fight with Twitter?
Yeah, well, boy, that's a really complicated one. So the fight with Twitter comes up under the Communications Decency Act, which generally, regulates the content of what mass communication providers can publish to the public. There are substantial unresolved questions, and I don't see any way how this doesn't get resolved ultimately by the Supremes once a suit is filed, which is inevitable. That what are the limits of the First Amendment on the one hand versus the fact that here you have a platform that allows mass communication on the other. That is a great flashpoint of technology outpacing the law, which is not unusual. Technology outpaces the law all the time, but now when you can bypass the regulated channels of communication in order to reach individuals directly, what can private companies do in order to regulate speech, censor speech altogether? And I don't know. I'll be candid with you. I don't know how that goes. I think there's great arguments on both sides of why a private company should be allowed to censor speech at its discretion, and of why, in this circumstance, that should not happen. So in terms of executive orders generally, you've got to look at what the scope of the order is. If the scope of the order, and to be clear, executive orders, the use of executive orders goes back to George Washington. So everyone's used them. It's just they've only recently come into vogue as a means of blunt force regulation, but blunt force legislation. So if the scope of the executive order is tied only to executive agency functions, well, there's no problem. That's the same as if, a CEO is issuing a memo to his company that we're going to do, we're going to change our working hours from 8 to 5 to 8:30 to 5:30, whatever. It's when it tries to go beyond the scope of the executive branch that you run into problems. When it starts to impose obligations on citizens or private companies or whatever, that crosses the line into legislation. Now we get into, well, okay, has Congress in some way, shape, or form delegated its legislative function to the executive, and the executive is issuing an order that is within the scope of that delegation, and does it exceed the scope of delegated authority that's been given to him? And so that's just that's a case by case situation to evaluate. So in general, I don't know that I'm necessarily concerned by the number of executive orders that are issued. I'm more concerned by the number of executive orders that are increasingly issued by presidents that don't stay within the parameters that are set for them.
We have a question on what, in your view, is the most effective check, institutional or otherwise, on the power of the president in the 21st century? And maybe I could just put a gloss on that question by asking, is that legal or is it political, if I can divide it that way, or otherwise? How do we check the president? What do we do?
So I think historically, the best check against a president is shame. I think every president is concerned with what is their legacy, what will they leave behind, and I don't know that any president. I can't speak for. I can't imagine that. That question of legacy doesn't weigh heavy on a president's mind every single day. And so, taking the Nixon example, I think that is a great illustration of where a president could have forced a monumental constitutional crisis. The Supreme Court had ruled against him because, frankly, political favor was so far on their side and against Nixon's to where they could override executive privilege to get the tapes that had been subpoenaed. And it was certain that Congress was not only going to impeach but also convict the president. And Nixon could have said, I'm going to disregard the Supreme Court. I'm not giving them any tapes. And to the extent that you guys try to impeach and remove me, I'm not going anywhere. And I honest to God believe this, if it weren't for ultimately his sense of shame, I think that he would have done all those things. I think he would have stayed there and forced the biggest constitutional crisis of all. So in terms of a legal check on the president, I don't know that there is one, honestly. I don't know that there is one as long as the president refuses to abide by the decisions of the judiciary and Congress won't protect the court. In the absence of those things, the individual or a state has no recourse against the president. In terms of Congress, their recourse against the president is not legal in the sense of a legal system. The standards for which you can impeach and remove a president are purely political. There's no threshold you have to meet. It's just if Congress thinks that you have committed high crimes and misdemeanors, treason, or bribery, they can impeach you and they can remove you, whether or not it's true. And even if let's say a president is wrongfully impeached, there's no recourse for a president. That's all a political determination. And so I don't know if that answers your question necessarily, but I don't think there's much legal recourse against the executive.
That's, I think, one reason why people are so concerned, many people, about sort of the breaking of norms, because that idea that the Congress shouldn't just impeach someone, president or judge, just because they don't like that person or don't like their views. It was tried back at the very beginning of the Republic, and the Congress decided that wasn't a good idea. It wasn't a good idea to do that, and they've stuck with that. And so as we erode these norms, I think these non-legal or political checks get weaker. I think, as you pointed out, there are very few examples where the Supreme Court has even tried to stop the president in real time. Maybe the Steel seizure case comes to mind from the 50s, but there are very few, and Nixon, but very few examples. I'm kind of ping-ponging between these sort of very general questions and some of the more specific ones that are coming up in the questions that have been asked. Could you talk about the Emoluments Clause? It's an exotic clause of the Constitution. I taught constitutional law for 25 years, and I don't think I ever mentioned the word emoluments in all that time.
Right.
And now that I'm not teaching that course anymore, it's an issue. Could you talk about that case and those issues and your views on that?
Yeah. So, emoluments is one of those words that no one uses. And if it makes you feel any better, Bill, when I went through law school, emoluments was never mentioned. I mean, that's what, who would care? Why did that? I mean, 15 years ago, no one even thought that would ever be an issue. What that's getting at is, the founders wanted the president to have a fiduciary relationship with the United States and with the Constitution of the United States, that he or she would always act in utmost good faith towards the Constitution without a cloud of impropriety, actual or perceived, that there was never a conflict of interest. That's what it is. It's an anti-conflict of interest policy. And so when it comes to the Emoluments Clause case, there's so many rabbits to chase about that. I mean, the issue they're litigating now is whether or not you can even bring an Emoluments Clause case, right? Before you even get to the merits of it, can you even bring it against the president? So let's assume that you can. Now you're in civil litigation with the president to decide if he has a constitutionally prohibited conflict of interest, if there's something that might jeopardize his fidelity to the United States. Discovery, the process of legal discovery on that issue is going to be hellish. Discovery is already an awful thing that plagues civil litigation. I can't imagine inquiring into the president's assets and entanglements to decide if he has an improper conflict of interest. So practically that's problematic. It wouldn't surprise me if a court said, yeah, we're not going to expose a president to a civil lawsuit that would probe all of his entanglements while he's the president of the United States. And if that's the case, what is your remedy? Let's say that you ultimately prove that the president violated the Emoluments Clause. Okay? If he's no longer the president, then who cares? If he is still the president and you prove your case, then what? You're going to get an order from the court that says, President, you must vacate your office, or you must divest yourself of those entanglements. that tees up a great situation where a president says, no, you in what army? I'm not saying there shouldn't be an Emoluments Clause. I think it's an important thing to have. But I'm wondering what the actual remedy for it is, apart from Congress doing something about it. And if Congress does nothing about it, then I'm not sure that anyone else can either.
Right, obviously, except the voters, right? I mean, that's in a
Sure.
sense, the ultimate remedy, at least in a first term, is that we have the opportunity to vote.
Sure.
But even midterm elections or others, I think, is important too. We have a few minutes left. I know we have a kind of hard stop at 1:30. I want to make sure everybody's aware that this is just one of many, many events that the World Affairs Council, the Upstate, and Upstate International sponsors. And we have done many of these in the past. We're doing many more in the future, and we would love to have you join us right now via the virtual media, but eventually we hope to get back in person and serve real food. Our next event, I just want everyone to be aware, is on Tuesday, the 16th of June, so in a couple of weeks, from 3:30 to 4:30, partnering with Upstate SC Alliance and the European American Chamber of Commerce for a lecture on doing business in Belgium, a little different issue here, doing business in Belgium and the Netherlands post-COVID-19. Just gives you a sense of the scope of our interests in the World Affairs Council. Consul General William de Baets of Belgium and Ard van der Vorst of the Netherlands will discuss trade between their countries and the US and the impact of the pandemic. So for more information and for all of our events and to join Upstate International World Affairs Council, please visit our website, which is www.upstateinternational or just upstateinternational.org. So thanks for that. The general question of sort of theories of presidential power, Bill Barr, the Attorney General, is known for taking a very expansive view of presidential power, sometimes known as the theory of the unitary executive. You want to take a stab at sort of that, your views on this idea that the president possesses all the executive power, and that therefore everyone who reports to him, whether they're cabinet level or even independent agencies, is subservient to the president and lacks independent authority. Is that, what are your views on that?
Well, I think, well, it's all fuzzy. I think to some extent, Congress can circumscribe that view of the presidency. And, well, I think constitutionally Congress could do it, at least historically. Now, I don't know what a court would be willing to defend or not. But historically, I think that it was very much the framers' intention that Congress could acquire whatever information it deemed appropriate in order to make decisions that would bind the United States to policy. And if that meant inquiring about the performance of executive officials, then I think that there's a space for Congress to to subpoena folks to come testify, and they've got an obligation to. So now, that being said, I do think there's also a space for the executive to have room to process and to vet and to engage in communications that are properly considered privileged. But I don't subscribe to Barr's theory of executive power that it is just unfettered. I don't see any basis for that in the Constitution. I don't see any basis for that in the Federalist Papers. And I think that runs a substantial risk. If you follow that train of thought through, that runs a substantial risk of resulting in the very tyranny that the founders were seeking to avoid by getting as much power unchecked out of the hands of the executive. So no, I don't agree with him. I get why he's saying it, but I don't agree with him.
It ties back a little bit to the executive order question, because there are agencies, so-called independent agencies. The Federal Reserve Board is an example, or certainly the Federal Communications Commission, where they're headed by appointees, sometimes presidential appointees, sometimes others. But the point is that the argument, at least, is that the president, legally, Congress's position at least, is that the president cannot simply remove these individuals if they don't decide decisions the way he wants them to. Do you have any thoughts on that?
Well, it makes me wonder what the scope of the impeachment power is. So Article 1 says that it's Article 2. It talks about impeachment and the ability of any officer of the United States to be subject to impeachment and removal by Congress. Let's imagine for a moment that Congress had a backbone, and the Speaker said, "Okay, Mr. President, you want to take the position that everyone in the executive department is covered by privilege. All right, then I'm going to take the position that everyone that you say is covered by privilege is subject to the power of impeachment and removal. And now I'm going to start scheduling impeachment and removal proceedings in my house." Now, you want to talk about causing a constitutional crisis? That'll bring us there. That'll bring us there real quick. But I think that, I'm not saying this is healthy or wise, but that door swings both ways. And if a president wants to say, yeah, everyone on down to the janitor that works in the executive agency reports to me and me alone, and I can tell them not to go talk to you, Congress. All right, that's fine. Then Congress, will put them on trial.
And it gets back to, I think, maybe your central message, as I read it anyway, that the legal system, the courts, are not a substitute for good faith, for involvement of citizens, for people taking responsibility for the positions of power that they hold, and that shame at some level, or public involvement, public protest is potentially a remedy, or perhaps the only remedy to presidential power. This morning, Secretary of Defense Esper came out saying he does not think that the military should be used, at least against the will of the states, to suppress the current protests or even violence that's occurring. He can be fired, of course, by the president. He's a cabinet official, no one doubts that. But then we get potentially into a kind of Saturday Night Massacre scenario in which perhaps others in the Defense Department will also refuse to carry out those orders, as happened in 1973 when the special prosecutor was fired. So there's a real nice example where I think the law and your main theme kind of come together. Buck, I'm going to give you the last word because we are just about out of time. If you want to make any final closing, as you lawyers say, closing remarks.
Yeah, sure. Well, like I said a few moments ago, I hate to be a Debbie Downer with all this stuff. I mean, there's just so much going on, and it is such a it's such a confusing season. Trust me, for those of you that are sitting out there and you've got questions about what does all this mean, how does the Constitution work, and how do these things relate to each other, I've got those same questions, and I don't have many answers. I think the only difference between you and me is the fact that I speak this language. The best that we can do is we who are on here and we as a country is go back to what the framers envisioned for this country to be and what we're trying to achieve. Those 6 things in the preamble that we're trying to secure the blessings of liberty for ourselves and our posterity, and to keep that at the forefront of all of our discussions with all of those that have different points of view than we do, maybe even, vocally, aggressively have different points of view than we do, but to understand that, we're all on the same team here, and we're all trying to keep this ship afloat, even as it appears that the world is going to hell in a handbasket around us. All I can say is I'm thankful that, there's more than 100 folks that decided to jump on this call, listen to me talk. Hopefully I've provoked some sort of thought or perspective on your end. And maybe when we all hang up off this call, we're a little bit more informed and better able to go weather the challenges that face us in this constitutional republic we're trying to maintain. So I thank everyone for your time and attention.
I want to thank everyone as well. I especially want to thank you, Steve Buckingham. Thank you so much for, it was indeed a great, very informative and interesting and provocative thought. I wish we had more time. I want to thank Tracy Fries and Kim Fowler and Rob Rowan from the World Affairs Council for their help in putting this together. And Kim especially for keeping everything on time, and all of us on the Zoom call the way we needed to be. Again, I want to remind you of our Global Business Connection event on Tuesday, the 16th of June. So that's 2 weeks from yesterday, if I'm correct, 3:30 to 4:30, about doing business in Belgium and the Netherlands post-COVID-19 with the Consuls General from Belgium and the Netherlands. More information and information on our other events and on joining the World Affairs Council, the Upstate International, on the upstateinternational.org website. Buck, I think if Zoom allowed you to hear the applause, I think they would be extraordinarily loud and long. And I want to thank everybody for their participation. Great questions and a great presentation. Thank you all, and have a great day.
Thank you.